Cool. Welcome, everyone. Let's just do these little bits of admin. Yeah, cool. Right. Yeah. Welcome, everyone. Good evening. I hope you're all doing okay out there. We have got something like 8 questions that have come in through the week. So thank you very much for those people. Every single one of them was anonymized, which makes me happy. So thanks very much for that. Appreciate it. On that note, please don't share personal data in the live stream chat. Ask questions as if they're about someone else. And let me just pin that so that's hopefully going to be visible. And I might just stick that same text actually to the other document. So yeah, guys, bear with me, guys. I've got it. There we go. Right. So yeah, it's not legal advice. We're going to do our best here to try and give you some information, which is hopefully going to be useful. But yeah, we obviously have limited information in front of us from situations that have been raised, so we'll do our best. And there's actually starting off from last week, there's a few kind of questions or a few, actually no, just a few comments really about the affordability stuff, which I'll come to shortly. I haven't got any gossip from the week. The LGO decisions today were pretty quiet. I don't know if anyone else has got any sort of news or anything that's seen people have seen stuff. Um, no worries. Hey, you right, Lynn? Yeah, if you're out there, say hello. Be nice to hear from you, see who's in the chat tonight. And yeah, just again, thank you for those who are subscribing and liking the videos, by the way, guys. It seems to be getting a bit of momentum in the old algorithm at the minute, which is cool. So getting on to the questions, or let's just start with the comments, actually. So there's kind of basically 2 comments just that kind of are quite similar. So I'll put them in first. Let me stick that in bold as well so we can kind of hopefully people can see that. So yeah, so regarding question 1, the citizens advice work with councils to do affordability assessments on potential private rental properties that applicants are required to view. They send both the applicant and the housing officer the report, which then could be used for any potential property offer by adjusting rental cost. I'm wondering how one would go about obtaining the guidelines the citizen advice use, as the council are following the reports, so the guidance has to have come from some government department somewhere. I actually think that potentially it hasn't come from a government department, but that is not to say that it's not going to be useful information. And similarly, so the second one, let's sort my camera out briefly. So again, regarding question 1, I know somebody receives PIP and also limit capability for work-related activity element on UC. However, when they're doing affordability assessment, they include these amounts when that's not the intent of PIP and LCWRA. This is for extra support. You need daily due to one's condition, and you shouldn't be used for offsetting shortfall in rents bills. Truth be told, the wide disparity between LHA and private rentals is almost a non-starter, and most definitely setting one up to fail. Eventually, shortfalls will ultimately lead to debts, then eviction, and cycle of homes to starts all over again. So both very, very cool, like very valid comments. In terms of the CAB stuff, I mean, Karis, do you know? Because Karis used to work at CAB, so I just wonder if you're aware of the document, or if there is a standardized document that all CABs use, or whether they kind of just use particular figures in different locations.
Yeah, it might be figures in different locations, but they use like a budget planner, which I was just getting up on the website. So I'm not aware of like policies and documents, but I was gonna say the one thing you can do is ask the council for it, or ask the CAB what guidelines they use, because it might be different in each area.
Yeah, yeah. So speaking of which, we asked the Bedford Borough Council what figures they used, and they spun a bit of a yarn saying, well, we don't have any standardized figures. We make sure every assessment is done on an individual basis and all that sort of stuff. So it's like, okay, well, that doesn't really help us out. So if we do kind of find anything, so we are long overdue to do a proper video on this channel about affordability. The reason I've been slow doing it is because the case law is so vague and unhelpful at the moment. But that leads us on to the second point that someone's made, saying that, essentially housing officers or councils are, kind of using the amount that people get from PIP and limit capability for work as a way of kind of topping up that shortfall. And as this person correctly says, that's not what it's for. However, it seems to me, having read these 2 cases, so one's called Bapti, one's called Patel, it seems that approach is open to local authorities, even though the DWP says this is not for, this is for things that are going to help you with your disability rather than anything else. So effectively, and what housing officers seem to be saying is that they will use the actual amounts that you need to deal with your disability. So if it might be taxi fares, it might be particular specialist food or whatever. They will, rather than looking at what you're getting, they'll be looking at what you actually need to spend, which didn't used to be the way it was when we had the Samuels v Birmingham case in 2018. That was kind of the wrong approach. However, as that Samuels case came out, the Homelessness Reduction Act came out. And another reason to hate the HRA is that it also changed the wording of the Code of Guidance, which basically meant it allowed the councils to kind of use this. So that Supreme Court judgment in Samuels only kind of was actually really there for a couple of months really, before it then got undermined again by this new wording of the Code of Guidance. So not sure if any of that was intended, but that's where we're at. So yeah, we do. It's such an important issue. We do need to do something about it, but as in do a video about it. But as I say, I'm waiting for some kind of inspiration as to where we actually find out what the clear kind of rules are. So hey, right, Mary John, you right, Ginger. So yeah, so that's all I have to say about these first 2 points. If any of you guys have anything to add to that, let me know. If not, we'll get on to the actual questions. Just for those who are watching who haven't been to this before, people ask questions on any video on the channel, which is my preference because there's no character limit. You can basically put your whole question in there. I'll then bring them here. I'll prioritize the ones that are anonymized, and this week they all are anonymized, which is awesome. Once we've got through these, we'll then go across the live chat to answer any questions that are coming up there. So that's the kind of the order of service, so to speak, which then brings us on to this next question. Well, the first question, I guess, if you look at it like that. But so here, so what if this person's IDVA, so independent domestic violence advisor, homeless officer, tenant services officer, and places like shelter, and not giving any answers on what to do about ending the joint tenancy. So this is someone who is experiencing domestic abuse or at risk of domestic abuse. Let's say them. I think they've actually left, or if they're certainly thinking about going into a refuge or something. And they've been, I think, if I remember correctly, they were told if you end the joint tenancy, you'll be intentionally homeless. Now, that is factually incorrect. You cannot be found intentionally homeless from accommodation that was not reasonable to continue to occupy. And if you're at risk of domestic abuse in your home, then it would not be reasonable to continue to occupy. So it is impossible to be found intentionally homeless. But this kind of next set of questions is really about the nuts and bolts of actually what happens next. So, and what would happen about things like rent arrears that might unavoidably build up in this situation, like having to claim housing benefit at temporary accommodation instead of property where there's still tied into the joint tenancy. Now, on that point there, certainly the way it used to be before universal credit came in is you could have two housing benefit claims open at the same time for basically exactly this situation. And I'm pretty sure you could have that arrangement for up to a year. So it would be quite common for people staying in a refuge or something that they still have a joint tenancy, they'll still be liable for the rent. So they're still kind of getting housing benefit for the joint tenancy, but they're obviously also liable for the rent or service charge, whatever you want to call it, in the refuge. So there would be the ability to have these joint claims. I am assuming that that is still the case, but I actually don't know for sure whether you can kind of have these kind of simultaneous claims. But even if it's not possible, it comes back to this idea that any accommodation the council offer you has to be suitable. Part of the assessment of suitability is going to be whether it's affordable. If you can't, let's say you can't claim housing benefit for temporary accommodation, which, as I say, I think you can, but if you can't, it would then be on the council to make that accommodation affordable for you. So I've used the example quite a lot. So I worked with two cases like this in Bedford. Actually, both cases, the survivor jointly owned their home, which meant they were not eligible for housing benefit at all. And yet the council had a duty to secure suitable accommodation for them, which meant it had to be affordable. So certainly in the case I was really involved in, the council basically offered the temporary accommodation at £1 a month for kind of peppercorn rent. So that's I guess a start of an answer. Do you guys have anything to add into this one, or kind of confirm anything about the dual housing benefit claims or anything like that? I mean, it's very frustrating that none of these professionals involved is actually giving advice about ending the joint tenancy. I think the kind of the cautious way forward would be to proceed with the homeless application, because I'm assuming that's what we're talking about here, and wait for them to accept the main duty, which will be owed almost certainly, and then just end the tenancy. But again, there needs to be some really careful planning around that when you're doing it, because it's probably going to push up the risk of further domestic abuse from the perpetrator. So yeah, as I say, that's my answer. They should be. My other answer is these four professionals or three professionals, or whatever, they should be doing better. They should be kind of giving some clear advice on that. But yeah, do you guys want to kind of add anything into that at all?
Yes, just on the benefit side of things. Sorry, Will.
No, go on.
I'm fairly certain. So you basically you get housing benefit for temporary accommodation, a housing element for universal credit. And I wouldn't have necessarily huge amounts of confidence, particularly as like in this area, it seems not many of the workers know what's what, and that your local sort of work coach or what have you might know what's what. But you, as long as you're explaining the situation and you're being clear and honest and transparent and all of that with like, look, this is what I am also doing. This is my current address because I'm now in temporary accommodation. However, the housing element is for this. It gets slightly messier if it's a joint claim. Again, a lot of job centre hubs will have domestic abuse advisors and specialist workers. So again, it's worth speaking to them. Because if you've got a joint claim, they'll know what to do to sort of like get around that. But yeah, you should be able to claim both. And like you said, if not, it's down to a local authority and they can do some sort of peppercorn rent or something.
Yeah, cool.
And sorry, I would be saying talking to the rent department. It's a different department from the homeless team. So they're copied into what you're doing. And if you get the dual benefit, so you're still a joint tenant until you it's contractually left. So there's a contract here. So until you formally left that tenancy.
Yeah. I would also say as well, just thinking aloud really, is that if it was me, I'd probably send an email to all of those professionals, copy in the local counsellor, go reach out to your local counsellor first, and just basically ask the question, look, this is my situation. Why is no one telling me what, where I stand with this joint tenancy? Why is no one giving me this advice? And I think once you kind of send an email out like that, they kind of, kind of kicks them into a bit of action really. But the IDVA, the homeless officer and the tenant services officer should all be able to give that, they kind of give some advice and clarity around that. But as I say, I think the textbook answer is get the joint claim up, or the dual claim up, should I say? Sorry, get the dual claim up and running. If it's not possible, if you get knocked back, then it's still on the council to sort that out. So you just got to put everything in emails, keep it all in an email, and then wait until the council make a final decision, which is highly likely going to be that they owe you the main duty. But and until you get to that point, kind of don't end the joint tenancy. So yeah, anything from you, Will, on that one? Are we good on that one?
Just a couple of little things. I'm sorry if I'm a bit disorientated. These questions, they're not all connected, are they? Or are they connected? Because they seem to sort of.
Yeah. So this one follows on. We asked this kind of followed on from a question we had last week.
Oh, I see.
Which I've now. So that's kind of what the context is. I should have actually brought up that question as well. But yeah, that's kind of so I think that we are answered some stuff around the situation last week, and then there's this kind of follow-up question this week with it.
Yeah. So the only question I've got, apart from the thing about what if all these people are not answering questions, I mean, that's pretty worrying. But I mean, I guess I can't really comment other than what you said. If you should write to everyone and maybe consider making complaints if people are not answering questions. But it's difficult to ask precise questions about something complicated, if you know what I mean, because you sort of need to know the answers in order to ask the right questions. But what I would say about joint tenancies, and I don't want to go off on a tangent, but just the problem with ending a joint tenancy is that it can be a sort of nuclear option in that it destroys the tenancy for both tenants. Now, I'm not saying this because I'm a sort of spokesman for domestic abusers who I want to make sure they keep their tenancies despite driving their partners out. But it could be that if somebody if a relationship breaks down and they want to get off the tenancy, you don't have to necessarily end the joint tenancy, because then you're ending the other person's tenancy. What you can do is ask the council to make arrangements for a tenancy to end, and then a new tenancy to be granted to the other person. I just had a case the other week where a very vulnerable person, his partner moved out. I can't say what level of abuse there was. There may not have been any. But the housing officer, she just said, I want my name taken off the tenancy. And the housing officer said, oh, great. You're giving a notice to quit, are you? And they then terminated the tenancy. And 6 years later, because it's local council, we're in court arguing about whether. And she sent a message saying, I never wanted to end the tenancy. I just want to get my name off it, which would achieve most of the things that people want. So if you are thinking of ending a tenancy, it makes it more complicated, because they'll probably say to you, oh, no, you can only end it by terminating it for both, but you can ask them to make arrangements such as accepting a surrender of the tenancy from you, which would terminate it, but then grant a new tenancy to the person remaining there. That obviously, if there's history of domestic violence, that's not going to be practical or attractive. But I mean, it could also make things worse if you're leaving a violent partner and your parting shot is to make them homeless. It's not going to make things easier. So sorry, that's a bit of a ramble.
No, that's all helpful. I mean, I think in one sense, yeah, these professionals exist to help people out in this situation, so this should not be like flummoxing them. If you've got an IDVA, it's highly likely you'll be being discussed at MARAC as well, the Multi-Agency Risk Assessment Conference, and basically there should be a detailed plan put in place. You know, when you get to that point of when you're ending that tenancy for reasons Will just kind of said, of how you're actually going to manage that risk. But yeah, I think in terms of the content of the email to send to everyone, it's just basically, I think all you need to do is explain your circumstance, effectively explain what's been said here, and just say why are you guys not telling me what my situation is and what I need to be aware of when I make a decision, because they can't make a decision for you, but they can absolutely tell you what the implications are of your different options. So I'll do that, and basically, if you don't get a response after a few days, potentially, again, if it was me, I'd probably escalate it. The fact you've got an IDVA says there's going to be evidence of domestic abuse already. So this person is basically guaranteed to be owed the main housing duty unless the council makes a final accommodation offer or final Part 6 offer beforehand. So this is one of the situations where you probably can be a little bit more, well, you can be more assertive because there's not really a risk of you being found not in priority need. So yeah, I think it goes back to basics. Be methodical, keep it all in writing, keep chasing them. This is absolutely reasonable questions that you're asking here. They get paid a lot of money between them, probably 6 figures between them. They should be able to answer this stuff, just very easily, basically. So yeah, hey, right, DC. You right, Bina? Cool. So next question that's coming through the week. Where are we going to? Here we are. So this one is from a councillor, and I've actually got a bit of info about this, as in a elected councillor, not a therapy counsellor. So I was wondering if you could help me with some legal housing advice, please. This is happening in my ward via a Labour administration. I'm an independent, and the elderly, vulnerable residents are understandably so upset. So let me go back a step. This is part of like a trail of things. There is a block of flats. It's council owned, council tenants in there. I think it sounds like it's kind of for older people, and they're going to demolish the block of flats. And there doesn't appear to have been any sort of reassurance for the tenants, some of whom have lived there for decades, what's going to happen next. So I think I've kind of asked around about this already, but I think the answer is going to be that there should be something specific put in place to decant them and basically rehouse them without having to make a homeless application. So they would basically get transferred to another tenancy somewhere. But kind of if things really didn't work out, I'm amazed they kind of a group of politicians are going to go forward with demolishing a block of flats for older people, and they're not going out of their way to reassure those tenants, because the part of the message was the tenants were really worried about causing a fuss because they thought they're going to get kind of screwed over by the council. So clearly there's been very little kind of communication or effective communication with the older people living there. But as I say, it seems that the answer is the council will essentially have some kind of specific management transfer or some kind of specific thing which will mean that people don't have to go through the whole temporary accommodation process and so on. And that's pretty understandable. You think it shouldn't really need asking, but that's what I've been able to ascertain so far. Do you guys know anything more than that, or kind of have anything else to say about what I've just said?
I'm pretty sure there is a separate piece of legislation that deals with the rights of tenants who are having their properties demolished in that way. It wouldn't just be, oh, you're all homeless. I'm just Googling this. It happens so rarely that obviously I don't remember what the specifics are, but I just remember it's like demolition.
I mean, it's happened a few times at Bedford. There's a huge tower block that got knocked down about 10 years ago. So there's probably people in Bedford I can probably go and find out how they dealt with it. Although that wasn't council accommodation, it was social landlord, but same difference.
It says the council is obligated to provide you with alternative housing, usually within the same area, considering your needs and circumstances. This is just to put a Google response. That could just be a reference to a Part 7 duty, but I'm pretty sure. And I think there's an entitlement to compensation for the inconvenience of moving. And
Yep.
if anybody out there remembers this, please let me know.
That was the kind of message I got back, although they didn't mention any specific legislation. But I think that's cool. That's helpful. I'll go back to this person and kind of just tell them what's what.
Yeah.
If you do dig something out, let me know. I'll go to the next question in the meantime. So, number 5, if you're lucky enough to get a 6-month contract with a private landlord, do you have to vacate the property after that, or can you stay on if the landlord is happy with you? And how about if you're in priority need and get 12-month contract? So, this might actually be about to change a little bit this year with the old renters' rights, whatever it's called, act. I've not been paying attention much, as you can probably tell, because at this stage is not really sure. I'm not really sure what difference it's going to make. So the answer is basically on a normal assured short hold tenancy, once the minimum 6-month term expires, basically the tenancy will continue to roll on. You'll continue to pay rent. And unless you or the landlord serves a notice to end the tenancy, then it will just keep going forever. So the 6-month and the 12-month is like a minimum term. I'm not quite sure what happens this year with this new legislation. I think assured short hold tenancies will all become, I don't know what the fancy terms are for it, basically, but as I say, landlords will still be able to evict people for no fault. They just have to kind of go a little bit, do a little bit more paperwork to actually get there. So that's my answer. Any of you guys want to add to that, change it, tweak it, whatever?
Yeah,
Oh, sorry, Karis, you go on. I'll carry on Googling this thing.
Sorry, it was just talking about the what do you say if it continues on? So as a short hold tenancy, if you come to the end of the fixed term and you haven't come to agreement, it will just roll over. So it'll become like a renewal if you agree, and it just becomes a periodic tenancy under statutory if you automatically if you've not put in a notice to put on either side, the tenant or the landlord.
Yeah, cool. Okay. Someone just commented there about question 4. So they would need to ensure they have not given a starter tenancy. They should be given a compensation and removal costs should be covered. Yeah, cool. That's helpful. Thank you. I mean, the kind of gist I got was that these tenants have been there for many years, so I hope none of them are on starter tenancies. I didn't get that impression, but yeah, I'll feed this information back to them. Just to say as well, so I'm really sorry I just deleted someone's comment, not because it was rude or anything, but just because it was in the first person. So please just ask again if you can anonymize your questions, put them in the third person. You'll notice that the questions we put here so far are essentially they're asking the same information, but it's phrased in such a way that you're not having to put your personal data on the internet. So next question. Friend currently has a failed review which has progressed to going through to court action. Apparently no priority need despite CMHT intervention, admission in review of disability and an enhanced PIP award. You couldn't make this stuff up. Still in property waiting bailiff removal. A significant change of household setup is imminent with my friend's main carer, a family member having come to an end of the road and looking at leaving the household, having found themselves a room to rent. Should my friend submit a fresh application with a change of circumstances once it happens? And what do they do about the situation regarding what is happening in court? It's been submitted and the barrister is now involved. My friend's mental health is rock bottom. Thanks for your help. Blah, blah, blah. So, really good question. This will actually be a very, because my guess is, I obviously haven't seen the decision. My guess is the council said, yeah, you've got these problems, but you have got a carer and they're going to look out, they're going to look out for you, and then they're going to basically mitigate any risk to you. So if the carer is now moving out, then that's a change. Yes, a change in circumstances, but that is actually going to be very relevant to the priority need decision because that person presumably is not going to be available to provide care anymore. If you haven't already, get a Section 9 assessment under the Care Act. So approach adult social services and get some help from them, get assessed by them, just kind of get that additional information. So this might be a different answer you're going to get from me as opposed to Will and Karis, because me and Shannon aren't lawyers and they are. But if it was me, I would trigger a fresh application. But obviously in a situation here that the barrister's already involved and so on, I mean, I guess my suggestion would be go speak to the barrister and say, this is what's happened, what should I do? So the good thing about making a fresh application is there are new circumstances. It is more than trivial, so you can start the whole process again. but there is a risk that they'll say, oh, there's still no reason to think you're in priority needs, and so you kind of it's not a kind of foolproof plan. But yeah, if as I say, if the barrister's involved, I would hope the barrister would, presumably the solicitor is involved as well. I would hope that they're reassuring this person and kind of actually giving them a bit of this kind of practical advice about what they can do. But yeah, if you didn't have a lawyer, I think I would personally, I'd restart the whole process and make a fresh application on that new information. But as I say, Will and Karis might see that differently, given that they're kind of their experience is as solicitors. So, Will or Karis, what do you reckon?
Sorry, I didn't concentrate enough to. I was looking at that. I'll just go through it. It sounds.
Yeah. So yeah, I'll let you read it through. Meanwhile, Shannon and Karis, you got anything to say about this one?
I'm happy to fill the silence while Will's reading it through. But I'd agree with you.
Thanks. Could I just interrupt you, Shannon? Sorry, I had to delete another thing on. So just the person whose messages I'm deleting, I'm not trying to be difficult. You're putting them in the first person. Just look how other people are asking questions and see that they're not actually putting their personal data in there. So please just rephrase your question, put it as if it's a hypothetical question about, what if question or whatever, and resubmit it, and we'll kind of get around to it as soon as we can. So yeah, sorry, Shannon, I cut you through there. Were you just basically saying?
I was literally just to say I would make a fresh application as well in this instance, but I'm not a lawyer, so yeah, I don't know if Will's finished reading it now.
Well, I think it's all you can do, isn't it? Really, I mean, in theory, I've often thought with decisions like this, although councils are likely to sort of say, "Oh no, it's more than 21 days," and we've had a review and you haven't appealed. I think if you put some evidence to a council and say that these are the things I don't think you considered before, plus there's been a change in my circumstances, it'd be very hard for them just to say no. I mean, they'd have to say, no, hang on a sec. Yeah, they'd have to say, no, we're not processing it. And then you'd be into a challenge. And the threshold, as we know from these recent cases, is so low that they'd probably consider it and then do a new decision.
So in terms of getting a roof over their heads, because there's still, there's a whole other question here about kind of waiting until the bailiffs come, but let's just kind of sidestep that for a moment. In terms of getting a roof over their head, so obviously councils have a duty to provide interim accommodation if there's a reason to believe that someone might be homeless, might be eligible, might be in priority needs, which if you make a fresh application, I'd say, yep. As I say, I'm basing that kind of on speculating that they're essentially trying to say that the carer is going to negate the risk to the person, and if the carer's moved out, then actually, that won't be there anymore. And the councils have a power to house people whilst the review and the appeal process takes place. In basically similar circumstances to that low threshold. But I guess a question I've got would be is, if the council played really hardball and said, no, we're not going to house this person whilst the appeal takes place, then the lawyer and the solicitor and the barrister have to go and challenge that. Does that leave the person without accommodation for a significant amount of time, or any time, I guess? Is that a risk that the council could just be annoying, and then by the time the courts actually process the paperwork, it's 5 months down the line and the person's still without a roof? Is that a risk?
It could be done very quickly, actually, because if we just think it through, if the person makes a fresh homeless application, the basis of the application would be, I'm homeless and I'm in priority need. It would also presumably be, I'm unintentionally homeless, I'm eligible, and I've got a connection. But if you just focus on those two things, then if you're going to make an application on those terms, then you'd also be saying that a Section 188 duty arises. And if the council say no, we're not going to process the application, then that's arguably challengeable for failure to process an application. And if they say, yes, we'll process the application, but because it's you and we're treating you as a second-class applicant because of your background, we're not going to give you temporary, then you could challenge them for Section 188. And so that would be by way of judicial review proceedings. And that can be done really, really fast. Literally, you can send a letter to the council on Monday saying, if they're going to be home, if the bailiff's coming on Thursday, send a letter to the council saying you've got until lunchtime today to house them, or else we're going to court. And then you could get into court on Wednesday or even Thursday, and you can have an order within hours of. I had an order once within an hour of emailing the papers to the court, which is just incredible. So yeah, you can get it really fast. But if there's a barrister, this is the one with the barrister involved, isn't it?
Yeah.
So I hope the barrister is involved on instructions from a solicitor. Otherwise, maybe, I mean, not that the barrister isn't entitled to help out, but they could be direct access. But it sounds like the person may be entitled to legal aid, which would cover judicial review as well. So I hope that's reassuring. So I would say make a fresh application, and if as they inevitably do, they say no, then get a pre-action letter sent over, and get ready to go to court. Hopefully, get a solicitor to take them to court.
Yeah, I mean, I'd have thought if the solicitor, I mean, I'm assuming a solicitor is already involved, so I'm hoping that it'd be a case of discussing it with the solicitor and kind of saying what's going to happen. I've just unchecked because I'm going to just bring the code of guidance. I know I don't want to go down this rabbit hole too much, but just to kind of quote this bit of the code of guidance in bold. When they say stuff in bold, they really mean it. So housing authority should ensure that homeless families and vulnerable individuals who are owed Section 188 interim accommodation or Section 193 main duty are not evicted through enforcement of an order of possession as a result of failures by the authority to make a suitable accommodation available to them. Now, I guess what the council is probably going to say at this point as well, you know, they're not vulnerable, but they clearly are. So, yeah, just to kind of say that as well, I don't want to kind of, you kind of end up with two issues rather than one if you kind of go down the route. So I think if you focus on making a fresh application and kind of, yes, as Will just kind of said, just kind of go down that line, then hopefully that'll be enough. So
thinking it through, if you make the fresh application, the danger is they'll say, okay, we're not going to fall for that one because we'll accept your fresh application, but hey, here's an instant negative Section 184 notice saying thanks for coming back, but you're still not vulnerable, so goodbye. In which case you then have to go for a Section 202 review, and then you'd have to request exercise discretion to accommodate pending review, and another judicial review if they don't do that. So it's a bit like a game of chess here. Your move is to make the application. They then say no. You request a review and JR them for not accommodating pending review. Did I go through that too fast, or does it make sense?
No, I think that's good. I mean, JR judicial review, just this like court process, just for anyone wondering. And sorry, Shannon, go on.
I was just going to say, would it not make sense as well for the person to maybe make the fresh application in a neighbouring local authority? Because then that neighbouring local authority doesn't necessarily have the prejudice of already being like sunk into a negative decision around priority need. You've given them that low threshold reason to believe. So you trigger interim accommodation. And then later down when they work out local connection and stuff, they would refer you back, but you'd still be in interim accommodation. But they refer you to the first authority. I just wonder if it maybe gets over that first hurdle so they're in accommodation.
I think if the solicitor wasn't involved, I think then I think you're gonna have to kind of play that game. But I mean, I hope if you've got a solicitor and barrister involved, they're gonna just as Will kind of says, like play that chess game. Just to say as a bit of a tangent, there's a case called IA versus Westminster, and that essentially established that when you've got these kind of different organisations involved, like CMHT, then, and it might have happened already, but the council do need to make inquiries of CMHT. They can't just make a same-day non-priority decision legally without kind of consulting that kind of support service and potentially looking into the whole reason for the PIP award and that sort of stuff. As I say, it doesn't mention it here, but I'd be surprised if adult services weren't involved. If they're not involved, then get them involved, because there's probably a bunch of information they will also have about this that will be helpful.
So I would add that also talk to your doctor and mental health professionals. They can write a letter on your behalf about your current mental health status. If it's at rock bottom, you should be talking to them, and they can help you with the adult social care services assessment and with the homeless application.
Yeah. And I guess just kind of deal with the risk that the kind of housing issues and then kind of secondary issues they're causing on the person's mental health. But yeah, I'm hoping within that there's some. So I guess in summary, talk to your solicitor, assuming you've got one. I think this person does. get an assessment under adult social care if you haven't had one already. You do that just simply by approaching the council and asking for one. And then potentially the solicitor can play the game of chess that they then do if they do a fresh application. So I think that sounds about right. Cool. Right. Next question. Number 7. I wonder how much pressure is too much. PHP was promised a week ago, but nothing happened really. Local councillors, 2 of them in the local MP, sent emails to ask what's going on. I thought the prevention duty would actually prevent someone from becoming homeless. 3 weeks left until Section 21 expires, but so far nothing but the person's trying to find themselves a place. Isn't it a bit silly to wait until the relief duty begins so the person officially being homeless and maybe incurring court costs? Regarding non-priority, it's a bit of a bummer for those who are deemed non-priority and have to challenge it. What if they're still deemed non-priority after that? If a nasty housing officer decides not to help them, they'll end up on the streets, I guess. So yeah, that second part, that is kind of the risk. If you're not in priority need, there's not that much that councils have to do. They certainly don't have to put a roof over your head. They have to take steps to try it, but that's rather vague. The point about the timely personalised housing plan, I mean, this person's absolutely right. Councils will get heavily criticised if this person makes a complaint to the council initially, then the local government social care ombudsman, because the whole point of the prevention duty in particular is to prevent the person becoming homeless. If you're taking weeks and weeks to actually get that far, to actually even do a PHP and therefore do anything useful at all, then you've completely frustrated the point of there being a prevention duty in the first place. And again, I've seen a number of, I mean, we talked, I think, on Will's live stream on Monday about the case I found with Tower Hamlets, I think, where there was the council got criticised for taking 10 working days to do a PHP. But I've seen other cases where, councils take 3 months, and it's like, well, prevention duty lasts for 2 months normally. So what use is that? But yeah, so the question of, how hard do you push? It partly depends on how confident you are you're going to be in priority need. So I mentioned earlier with the person who was a survivor of domestic abuse, seemed to me like there's already plenty of evidence there. There's not going to be much of an argument the council's going to have. They will find them in priority needs. But in a situation where it's not automatic, where you're having to rely on vulnerability, as we saw in that previous question about someone who's got presumably multiple care and support needs, disability, mental health issues, and they're still being told they're non-priority needs, you can kind of see how difficult it can really get. And it does, I was seeing a lot of this. I mean, I get the impression that London councils, they'll just say you're non-priority no matter what, and just see if you challenge it. That'll be their line. They'll just be difficult, basically. So, yeah, certainly my answer is you kind of have to sort of base your level of pressure on how confident you are you're going to be in priority need. If you're not confident, then yeah, you can just annoy them, and they'll just kind of just be even more difficult. So I think you have to kind of gauge that. I think if the councillors and the MPs are already involved and they're already kind of chasing it, then I think wait a bit longer, basically wait for them to get response. And then at the end of it, whether or not you get a good outcome, you can complain, and you might get a little bit of money from the LGSCO for the delays in issuing the PHP. We're talking like a couple of £100, so not a lot, but better than a poke in the eye, I guess. You guys want to add anything to that at all?
Sorry, Will.
That's right. You go first.
I was just going to say, because I can really understand how frustrating it is when you're like waiting for stuff to happen and you're trying to like do everything in your power, which is not a lot of power, but to help your situation. So I think if you decide to if the person decides like not to put too much pressure on or what have you, actually could spend some time really building up the evidence base. And sort of making sure they've got a really good letter from a GP, making sure that they've got, the evidence of how it might affect them, knowing what that they want to put into the PHP and making notes on it. And like, this all sounds like I'm just giving the person homework and saying, make notes for your PHP meeting. Actually, it's really worth doing because, I mean, the fact that this person is asked how much pressure is too much, and they've mentioned sort of nasty housing officers or whatever, they're not wrong to think that. And so I think when you're in that room doing a PHP, it can be quite intense. And so if you do make notes and you do have the evidence sort of beforehand and be as prepared as you possibly can be, and sort of not giving them wiggle room to say, no, you're not in priority need, that sort of maybe where I'd focus my efforts currently. And then once you've got that, then maybe sort of add a bit more pressure if needs be, if they haven't already gotten around to it.
Yep. Will, did you have something? I've got something to
Very,
add, but yeah.
very quickly, because I appreciate we still got to get onto the live comments. I just thought of another thing for that previous one about the one with the barrister involved. Did any of us suggest making a request for a Care Act assessment as well?
I think so, yeah.
Okay, because obviously the fact that if they've made a written request for a Care Act assessment for somebody that's got all of that need and enhanced PIP and stuff, the fact that the council will almost certainly not have got around to even starting the assessment would make a judge likely to make an order requiring the council to assist while waiting for that. And the other thing I was going to say about PHP, sorry, the last case, and this is just, I'll resist the urge to go further, but the prevention duty in my mind completely changes the job of housing officers in what were called homeless persons units, and turns them almost, if they were doing the job, I think as Parliament intended, to be like housing advisors like us. So they would look at somebody's situation and say, how can we help you avoid losing your home? But they still don't think like that. They just think, oh, just go away and come back when the bailiffs come. They can't resist. It's very difficult for them to get out of that mindset, partly because the introduction of these new wider power duties have come with no, as far as I'm aware, no extra funding. So it's difficult for local authorities to take on this role. And so they don't, so often they don't. And I've just made a complaint about one council where somebody was facing eviction, but she'd applied to get the warrant suspended, but they just accepted a relief duty and said, you're going to be evicted. And they didn't look at the fact that the judge had suspended it. So I've said they shouldn't have, they should have accepted a prevention duty and done something to help. So, sorry, that's the end of my
Nice, all good.
contribution.
Yeah. I mean, I guess I'm going to add something here that doesn't help this person out at all, but just to kind of say, if there are any professionals watching this, and I don't know if there are, it seems to be there's mostly people who are kind of going through it themselves. But yeah, I mean, this kind of thing where councils get away with just kind of shitting on people who have kind of got lots of issues and doing it systematically, doing it every day, that's something that professionals should be challenging. And it's probably what, so me and Shannon spend a lot of time talking about how cowardly a lot of charities are when it comes to kind of challenging this kind of practice. Because I've seen the question is going to come up in a minute, is someone vulnerable in priority need? The answer is yes, legally, this person here is highly likely going to be in priority need, but that's kind of just what the law says. Because councils are wholesale not following the law, they'll get away with it. Now in Bedford, this is what it was like in Bedford 10 years ago when we set Just Us up, and the first 2 years was hard work, just professionally as workers challenging that council to improve, but they did improve. And actually now they get it right, more time, probably the majority of the time. Whereas back then they were kind of getting it right, 5% of the time, if that. So I just say to any professionals watching, like this, I would argue this is the kind of the most unjust part of the system, and there's a lot of different injustices in the system. But this is it, kind of vulnerable people getting told they're not vulnerable, kind of just get left to it. Really, this is the thing that professionals need to sort out, and it can be done. But you've got to challenge the council. You've got to kind of win these kind of arguments and do it consistently. So yeah, rant over. Oh no, not that one. So yeah, just to say, guys, we are now full in the live stream. I kind of lost track of it, to be honest. But yeah, so there's no more questions. If you want to ask further questions, we need to roll it on to next week. And let me bring up the next question. I was pressed the wrong button. Awesome. So after a possession order, can a landlord apply for a high court bailiffs if the tenant is not in rent arrears? Will the tenant be liable for the cost of the high court bailiff's bill, or can the tenant be chased only for paying the county court bailiffs and the court costs? I do not have a clue about this one, so I'll leave it to someone else to answer. Basically, anyone know the answer to this one? I have a feeling it's going to be quite a simple answer, but I don't know what it is.
I think it's a couple of answers. One is yes, they can. If the landlord's got a possession order, then I think any breed of possession order can be transferred to the High Court for enforcement. Please, somebody correct me if I'm wrong about that. And then in liability to pay costs, I think that in theory the tenant would be liable to pay costs, just following a normal principle that if the landlord has to take reasonable legal action, then because of the tenant doing something or not doing something, then they'd be liable. But in reality, landlords very rarely come after tenants for money in this situation. If anybody out there's had experiences the other way, please let me know. But normally the landlord will just be so glad to get the property back that they'll be thinking, I don't want to waste any money. And they'll be, but usually the tenant doesn't have any money. And that may be the reason, or one of the reasons they want possession. And so they know that they're just throwing good money after bad. And if you try and recover, say you've got £500 legal costs or even £2,000 legal costs, it'd be pretty easy to spend that much money chasing the tenant, and then at the end of the day, you get no money out of them. It's so it's very rare that people come back to me and say I got evicted 2 years ago and the landlord's still chasing me. In fact,
Yeah.
it's never happened.
Yeah. Okay. Cool. Thanks, Will. Given the time and given how many questions we've got to get through, we're going to kind of speed on. So this is the last question that came in through the week. No, it's not. Let me get the actual last question. It's here we go. Here we go. So, friend initiated the homes application after receiving Section 21. No formal duty notified during the process. He's now received possession order, and the housing officer says he can only now start the relief duty. He's been told, not formally written by the housing officer, that he will be owed the main duty because of medical priority and so on. So that's nice of the housing officer to do that. Housing officer says he'll be given interim accommodation outside of the borough, or he could stay put and wait for the bailiff. If he chooses to stay put so he can keep looking for private rented accommodation in the area while wait for the bailiff warrant, does it affect his ongoing homeless application? Does it delay anything in the process? For medical reasons, he would struggle if he had to move to another area, so he'd rather stay in the area until he can, but keep the homeless application going in case he's not able to find a place. So, I mean, really good question. From the point of view of the homeless application, if the count, I mean, there's probably already been a delay here, so I'd argue that the council should have accepted the relief duty earlier. But now that we are, this is where it's at now, staying put is, I don't think, is really going to delay the process much. It does get a bit complicated, and ultimately, it seems, unless this person can get private rented accommodation, they're probably going to be in interim accommodation at some point in the future. But in one sense, if you can try and get through that 56-day relief period, given that this person is likely to be in priority need and so on, and therefore owed the main duty, I would probably say, I don't know, from that point of view, I'd probably stay put and just kind of keep my head down until that relief duty period is over. And this, so if you're in priority need, not intentionally homeless, the council should issue that final decision on day 57, as in 57 days after the relief duty been accepted. Now, obviously, that kind of brings into play the things Will just literally been talking about kind of, court costs and stuff like that. So you can't, we can't give you kind of a perfect answer on that. But I think that my thinking aloud, I think it'd be a case of waiting out the relief period, getting the council to accept main duty. That might well happen around about the same time that the actual bailiff kicks the person out of their property, and then they'll go into interim accommodation. The question about it being accommodated outside the borough, you need to go back to your PHP. I did a video about PHP today, just I put it up today. And I made the point that any accommodation that councils offer have to be suitable, and they have to take in your medical needs as part of that. Now, this person sounds like they've got quite significant medical needs. So if there's a good argument to make in terms of, I need to get help from this person, or I need to get access to this treatment center over here, and it's kind of it's fairly unique or something, then there's a strong argument to say that you would be housed in the area or kind of close enough. Bearing in mind that many housing officers will often say, oh, there's no accommodation here, there's we'll have to house you 200 miles away, as a way of putting people off. Now, sometimes they, that's not just an idle threat, they will do, but sometimes they just say it to kind of just put people off and keep people from kind of bothering them. And ultimately that person might end up, because in one sense, the housing officer can't say, well, we won't have anything available on that day, a couple of months away. They don't know that. They're just speculating. It's not until the actual day that the interim duty has been accepted that they will actually, know whether there's properties available or not. I know there's kind of, they can kind of give an indication, but they can't be that certain. So that's my answer to that question. Does anyone want to add to that or take away from it at all?
Very quickly, again, I would say it sounds like the housing officer is behaving badly, in the sense that no housing officer should tell somebody, we can only house you outside the borough. As you say, it may turn out to be that way, but they're still under a duty to consider locality. So I think if you're going to have a fight, you may as well start the fight now, because you've got a possession order. You should be asking for temporary accommodation. If there's a reason why you should be within the borough, and it's a good one, you might as well start fighting over that now, because if you delay it, you're only going to delay them offering you something outside the borough later on. And you could be getting your sort of ammunition, talking to the doctor and stuff now, and getting a solicitor if you can. Otherwise, you're going to be faced with they'll keep you waiting until the bailiffs come, and then it'll be the day before the bailiffs come. You'll have a choice between somewhere far away or nothing, which is a difficult choice to deal with. So I'd say start challenging it now.
Yeah, and I think although technically it's possible for a layperson to challenge location in terms of suitability of TA, it's one of the hardest arguments to make. So if you can get a solicitor as well, then get a solicitor. And I'll dig out the link for, if you just search for Will Flack Law. I always get mixed up because your channel's called something different. Is it wflack.com or willflacklaw.com? One of the two. I'll find it in a minute.
The YouTube channel is William Flack Law channel.
And then what's your website?
And then
with
the
the
website
list
is wflack. Yeah, I can't remember it.
So
it's wflack. If you search for wflack.com,
yeah,
then you'll find that.
Because Will's got here we go. So he's got. I'll put it into the chat as well. There's like a list of legal aid funded housing solicitors, which you can kind of get an approach. So first question from the live stream, guys. So yeah, number 10. Client wants to leave flat because of banging doors, constantly shaking the flat. Landlord been told and other tenants, but it continues and no one cares. What are their rights? I have a horrible feeling that your best bet is to essentially engage with environmental health, who might give you some recording equipment to kind of record how bad the banging is. And then even then, they're probably not going to do a lot. I don't know that you've got a whole lot of rights there. I mean, as I say, you're going to have to be really kind of persistent with that to kind of get anywhere. I mean, I guess one of the questions is there not a way that the landlord or whoever owns the block of flats to put some kind of closing mechanism on the doors that doesn't bang? I mean, obviously that is possible, so that might be something that maybe might fix it or not. And that might, if that would fix it, then that's maybe something to go for first of all, just by complaining to the the kind of landlord. But other than that, I don't really know how strong someone's position would be in that situation. Again, I'll open it up to Will and Shannon. Karis has gone walkabout, but I'm sure she'll be back. But yeah, can anyone do anything more than that, as far as we know?
I think, I mean, it's just a question of getting evidence, isn't it? Because it depends how bad the banging is and how sensitive or vulnerable to banging noises the tenant is. And the higher the levels on both of those, the more, and particularly the higher, the more proof you've got of that. Because obviously, if you've got doors banging all night and you can't sleep, I mean, that's a fairly no-brainer that it's not going to be suitable for you. But if it's just sort of once a week or something, but if it says they're constantly banging and shaking the flat, then that sounds pretty severe. But you're going to have to monitor that and get some recordings or evidence and perhaps evidence from neighbours and things. Because otherwise the council will just say, no, there's no evidence of that. We've spoken to the landlord, there's no problem. So yeah, that's what I'd say, just get the evidence together.
Cool. There's three questions that come next in the chat, and they're all about how much people will be able to claim and kind of local housing allowance. The answer is we can't tell you because we would need to know the local housing allowances and kind of your local circumstances. So in terms of what someone can do to find out, I guess if you're, well, Shannon, you probably know better. Well, you do know better than I do. Who would they need to speak to kind of answer those kind of questions? Is it they're just kind of work coach or whatever, or?
Well, so you can do that, but to be honest, there's lots of benefit calculators out there. So Turn to Us have one, Entitled to have one. So I would personally, if it was me in this situation, because you have to put in all your details, I think it takes about 5 to 10 minutes, but then it comes out and it's quite accurate, as long as your figures and stuff are accurate, and you can sort of, I've used it before to play around with like what if situations of like, what if I take this job, what if I move this place or whatever. So that's my recommendation, because it is specific to area and dependent on your income and savings and all that.
Cool. That takes care of about 5 questions. So that's a bit of relief. Thanks, Shannon. So the next question I'm actually going to transfer over is, I've lost it. No, that one, we've done that one. DC's just saying that the point she was making about, she was, sorry, I'm assuming it's a female, is the starter tendencies is that when we're talking about the block of flats with the elderly people in there, and they were saying that basically the important thing is to make sure that when they get transferred over, they don't get a starter tenancy, as in they get kind of a like for like security of tenure when they move across. Now, I get that's an interesting point. I don't know. I'll kind of include that in the information I give back to the council to say this is something you want to pay attention to. So thanks for that. I appreciate that. So I think again, there's more questions about benefits. Yeah, I'll refer to Shannon's previous answer to that. I think this is the next question here. So. If a person is privately renting in a different borough than they came from, how long until they're classed as having a local connection in the new borough they're staying in? Can they then approach the council? So if they're not homeless, then the definition of local connection will be locally set. Now, the definition if you are homeless is you can live, if you live somewhere for settled accommodation for 6 out of the last 12 months and or 3 out of the last 5 years, you have a local connection. But if you're living in private rented accommodation, although you'll be accruing local connection, at this point you're not homeless, so you won't be able to make a homeless application, and therefore you'll need to rely on the generic local connection policy that is set in your area. So what you'll need to do is go on or if you Google your council's name and then the term housing allocation scheme, you'll find the policy. It should pop right up. In fact, I've just actually done an Excel sheet, which I sent over to Will. At some point, Will will put it up on his website, I think, which is kind of like an index of every housing allocation policy in the country. So you can kind of cheat and kind of go to it that way. But yeah, so it will just depend. So some councils, it ranges between 6 months and 10 years. It just depends where you are. And if I remember correctly, this person is kind of talking about some sort of like Hampshire, Sussex area. So I think you're going to be looking at more than 6 months would be my guess for the housing register. And bearing in mind that if you're in privately rented accommodation and it's technically affordable and it's, kind of everything's okay, then you probably won't be able to get on the housing registry either. You might be able to apply for it, but they'll say you've got no housing need, you're suitably housed. Therefore, the best you can hope for is getting the lowest band. So there's not a lot of good, well, there's no good news in what I've just said there for this person, but I think that's the problem you're going to have is whilst you're in private rented accommodation, you're not homeless. If the landlord was to serve a no-fault eviction or something, given that the law's changing this year, but if they were to do that, then yes, you could then approach that new council. And if you'd lived there for 6 out of the last 12 months, you would have local connection. But that's obviously kind of a little bit further ahead in the future that you might not actually have an idea of whether that's going to happen or not. So again, there's more questions about benefits, which can't really deal with here. So unless I'm missing, so I think this is the next question that relates to housing law. Can you explain what happens when relief duty has been accepted? However, there aren't any LHA or private accommodation suitable. In 56 days, if you can't find anything, what happens? So it will basically depend on whether you're in priority need or not. If you're in priority needs, then you'll get an offer of housing at the end of it. If you're not in priority needs, they can end that relief duty on day 56 or 57, however you want to count it. And that's it. That's the end of the road for you, basically. So if you go into, in fact, there's 3 videos I recommend you check out on the channel. One is the one I did today about PHPs, personalized housing plans. One is I did one about what is the relief duty. So if you search for that term relief duty on the channel, you'll find a video about that. And you might also want to check out the video I did about will I get private rented or council housing? Because within that video, there's some stuff in there which will probably be useful for this person. In fact, there's a 4th video, there's a video which is called What If I'm Not in Priority Need? So if you check have a look through all 4 of those videos, I think you're going to get a much better answer than we can give in the time frame tonight, given it's now 8:30. Next question. Is there a way to get your own accommodation and not a shared one? So potentially, yes, but there's quite a few moving parts of this one. So the first thing to say is that someone might be asking this question because they're under the age of 35 and therefore they're only eligible for the shared accommodation rate with the local housing allowance. There are some exceptions to that. So for example, if you've ever been a victim of domestic abuse, then or since the age of 16, I should say, then you're exempt from the shared accommodation rate. You'll get the 1-bed rate no matter how old you are. Equally, if you've ever lived in supported accommodation for more than 3 months, then you'll be exempt. I think care leavers are exempt. There's some other exemptions which I've now forgotten. I think if you search on this channel, on the YouTube channel, and for the video, what is the LHA, or what is the local housing allowance, I think you'll get the information you need from that, because I include the exemptions. So that's the first kind of way I'd answer that question. The second way I'd answer the question is where potentially you've been placed in temporary accommodation, which is kind of shared, like B&B type accommodation. So you've got your own room, but you're sharing kitchen, bathroom, that sort of thing. And in one sense, unless there are specific medical issues, then I don't think you can. There was a really horrible case involving a lady who I think was incontinent, and she lived in shared accommodation. And effectively, I mean, at the end of the kind of the argument they had in court, the judge said, yeah, actually, the council was entitled to say it was suitable for that person to remain in there. So even whether she had quite a significant health issue, and it clearly had an implication on sharing accommodation, even then she was not able to kind of get the council to have to kind of put her in self-contained. I think, Will, you've kind of worked in cases where someone's got something like PTSD, like diagnoses like PTSD, where you can make an argument to say they need to be able to feel safe. They can't feel safe if they're around lots of people who've been very naughty and all that sort of stuff. Do you want to say anything about that one at this point, Will? Very quickly.
Well, it's just the point that if shared accommodation won't be suitable for you and you require self-contained accommodation, then you've got an entitlement to be provided with that. Obviously, it's not as simple as that, because if the council will deny that you need that, and they'll say it's very common that there's no evidence because somebody hasn't been to a doctor and had a consultation about that. But if you get a solicitor and you're eligible for legal aid, then the legal aid agency can pay for a psychiatrist to carry out an assessment, and that can involve diagnosis, possibly for the first time, that somebody's actually suffering from a much more severe condition than was previously thought. So, yeah, I would say that I think it's just starting to be recognised that quite how many people have got post-traumatic stress disorder and how serious it is as a condition, and also how really unsuitable for most people, let alone vulnerable people, shared accommodation is. And it's usually rather prison-like environments would accept that there's much more weed being smoked. Well, I don't know, actually, I haven't been in a prison lately, but I'm assuming that's a bit more controlled there. But I mean, there's chaotic sort of places which are not good for anybody with mental health problems.
I only caught some of what you just said there, Will, because I was just trying to catch up these quick comments, but I'm pretty sure prisons are about as chaotic as you can get with with all the drug use and all the stuff that goes with it, I think.
Yes.
But you put obviously your point still stands. Yeah. And I remember visiting a few people in prison, and there's some drama going on. Cool. So we're nearly through. Just to say, guys, if we haven't had time to go through your question this week, my advice is put it onto a video on the channel, anonymized, and then as you can see tonight, we start with those questions, so you can kind of actually guarantee you're going to get your question answered. There's a couple of questions here which I think we might have covered, but I'm going to stick back with. I think this kind of will group these ones together. So. Kind of following on from this idea of what happens if the relief period you're not able to find something. My friend got a 56-day notice that the council will find private accommodation, but that solution doesn't help as they don't work and it's very expensive. Would they evict my friend in any given case? And then there's a bit more. My friend got rejected housing bidding due to being away from the borough for 3 to 4 months, but came back for 23 months in that borough of Hackney. But before he lived in Hackney all his life. So
it's more to it, Mike. Sorry.
Oh, sorry. Yeah, thanks. Cool. That'll be why there's 2 dots. Nice one. Is there more than that? Yeah, there is. Okay, we're going to deal with this one. This one snuck through the old time limit there. Fair enough. So let me just stick this all together, and then we'll try and tackle it all. Oh, wrong button. Cool. Yeah, this will be the last question we cover. Just to say, there's a comment there about I will kind of mention this one a bit further down. If the council advises you to stay after Section 21 ends in writing, can't you just forward them the bill? Yes, you can. That's effectively what the LGSEO would do. So there's a couple of cases on the channel. If you search for the term bailiff on the channel, there's a couple of links in that video which has got the LGSEO decisions, one of which is a tenant getting money back. One is a landlord actually getting money back because the council advised the tenant to stay put, and the landlord was like, well, you know, I've lost money. So actually the council paid the landlord the court costs. So check that out. But let's go tackle this question here. So lived in Hackney all his life. Are there grounds for his friend to appeal successfully, saying that they have been in Hackney most of their lives? The 56 days notice after a relief duty question: can the tenant in temporary accommodation reject private accommodation PHP due to financial restrictions, or would they be evicted if they reject? If the local MP and ombudsman get in touch, would this postpone if being threatened to be thrown up? My friend's so afraid they're going to be evicted. Also, if they went private, how much support would they receive in regards to LHA, DWP shortfalls, and for how long till they wipe their hands of you? Okay, there's obviously a few questions here which I'll try and unpick. So local connection, I kind of mentioned already that the definition that applies to homeless people, there's 3 categories really. Residents, where if you lived somewhere 6 out of the last 12 months and or 3 out of the last 5 years, you have local connection. Now, my first thought is that it sounds like Hackney is essentially telling this person the wrong test, because it sounds like they've made a homeless application, whether they have, because the relief duty is owed to them. And therefore, if my maths is right, they came back for 23 months. If I'm reading that right in terms of this person's been there for 23 months, the last 23 months, they have local connection for the homeless application. So what I think Hackney's doing is they're telling them, oh, you haven't got the 5-year, whatever it is, you know, that you need to have it under the housing register definition, but the homeless definition is only 6 out of the last 12 months. So I think this person does have local connection from that point of view. But just to say, the fact that you might have been born somewhere and lived there for 70 years, if you move away for a couple of years or whatever, you can lose that local connection. Now you might still have it through family connections, stuff like that, but the residence is where you're born effectively has very few councils that kind of give that any credence at all. There are a few councils that within their Part 6 definition, the non-homeless definition, they do take that into account, but most don't. They'll just say, have you lived here recently? Basically, that's what they're looking at. So can tenants in temporary accommodation reject private accommodation? So on that point, I did a pretty comprehensive video, if I do say so myself, which I think the title of it is, can I reject the offer of accommodation or something? If you search the word reject on the video in the channel, you'll get the video. It's about 25 minutes long or something. It's quite complicated, but that I think will give you the answer that you need for that one. There's obviously quite a few questions here. Does anyone else see any questions here that I didn't just answer? Because I think ultimately it comes back to this point of, if you're not in priority needs, then there's the council at the end of the relief period can basically shrug and they'll wash your hands of you anyway. So there's not usually any requirement for a council to provide you support after you move in somewhere, because whenever you move in somewhere, if it's an offer of accommodation through the council, it must technically be affordable. So councils, it's very unusual for councils to basically give an LHA to someone when they move into accommodation, because they only last for 3 months, and in 3 months' time, if you're going to be unaffordable, then you're going to be coming back around as a homeless person. So so I don't know. Can anyone else see any questions in there that need to be answered still? As I say, I think the short answer is, in terms of local connection, you need to go back to the council and get them to actually give you the right definition of local connection. And in terms of being worried about being evicted at the end of the 56 days, it's all going to come down to whether you're in priority need or not. If you're in priority need, there will be further duties. If you're not, then there won't be. So yeah.
Sorry, the other question I think they're asking is, can they reject temporary private accommodation?
So I think there's tenants in temporary. So I think it's someone who's living in temporary accommodation, as in they're under relief period. So if they're in temporary accommodation now, and again, I think technically we're talking here about interim accommodation, but that says to me the council does have reasons to believe that this person might be in priority need. The way London councils seem to work is essentially, if you're in priority need, if you're in temporary accommodation or interim accommodation, that's probably a good sign that you actually are in priority need, because generally speaking, if they kind of haven't, if they're not satisfied of that, really, they're kind of very difficult from the start anyway. So my take on this is that they're under relief period. They are in interim accommodation because there is reason to believe that they might be in priority needs. And the council, they know that the council might then offer them what's called a final accommodation offer, which is a 6-month assured short-hold tenancy in the private rented sector. If they refuse that, that can be at the end of the game. So unless there's a very good reason to refuse that, that's lights out for that homeless application. There will be no further duty. So yeah, yeah, I think we got that one right. So I think that's it, guys. So yeah, I appreciate there's some more questions in after the kind of cut-off point, but we've gone 10 minutes over already. Again, I'll just say to you, if you've got questions, if you haven't had a question answered tonight, stick it into a comment, any comment on any video on this channel. I'll get a notification, and you'll then be guaranteed to have your question answered next week. So that's how it works. If it's a short question, I will answer it just in writing straight away. But other than that, thanks very much for all the questions tonight, guys. If you have not already liked the video, give it a like. That'd be great. I think more importantly, if you really want to help out this, kind of help get this information out there, if you're seeing people in Facebook groups, whatever, I see a lot of Facebook groups kind of going around. If you're seeing people ask these kind of questions and, hang on a minute, there was a video about this on this YouTube channel, feel free to share a video in those kind of settings, because certainly I've been in a few Facebook groups recently where there's so much misinformation shared around. It's just like, how are you supposed to know what's actually right or wrong? So feel free to kind of share that stuff out there. I think we're back on Will's channel on Monday, unless Will's going to say otherwise. In fact, I'm not.
I'm planning to be there.
So I'm driving back from Somerset that day, so I will be in a car at that point, I'm afraid, so I can't make it. But yeah, for guys who are watching tonight, if you haven't already, just check out Will Flack Law on YouTube, subscribe, you'll get notifications of videos, and you can also ask questions in Will's channel on Monday as well. So again, if you want to get one of those questions in we didn't have time for tonight, just put it onto Will's channel and he'll get to it on Monday night. So yeah, other than that, guys, take it easy. As always, try and break these legal problems you have down into little steps. Be methodical, keep it all in writing, and just keep going. That's probably your best bet in terms of actually winning these arguments. And if you're a professional watching, get your own counsel in order. Basically, this is unacceptable that so many counsellors are just kind of just fobbing people off and stuff. So it shouldn't be happening. But yeah, take it easy, guys, and we'll see you soon.